Hey boys and girls, today we are diving into the concept of purchase money resulting trust in Singapore. This legal principle can be quite intricate, but we'll break it down into simple terms and discuss Court of Appeal decision to illustrate how it works. First, let's understand what a purchase money resulting trust is. Essentially, a purchase money resulting trust arises when one person pays for property, but the property is registered in the name of another person. The law presumes that the person who paid for the property did not intend to make a gift to the person in whose name it was registered. Instead, the person who paid is presumed to retain a beneficial interest in the property. Therefore, this results in a trust. The person holding the title is considered to hold it on trust for the person who paid for the property. The Court of Appeal in the case of Lau Siu Kim examined the law of presumed resulting trust and stated that where A pays for the purchase of property, whether in full, the whole of it, or part of it, which is then registered in B's name alone or in both persons' name, okay, both registered name, there is a presumption that A did not intend to make a gift to B. Therefore, the property is held on trust, B holds it on trust for A. If A is the only person who paid for the property, then B holds 100% of the property on trust for A. If, however, the property is registered in the names of both A and B, whether jointly as joint tenants or 50%, 50-50% as tenants in common, but A contributed 80% of the purchase price, then it is presumed that A and B hold it in shares which are in proportion to their contributions. Therefore, because A paid 80% of the money towards the property, he's presumed to hold 80%, and B, who only provided 20% of the money, but on paper he's a 50% owner, therefore 50 minus 20 is 30%. So B holds 30% on resulting trust for A. It is important to stress that this is only a presumption, and this presumption is easily rebutted either by the counter presumption of advancement or by direct evidence of A's intention to make an outright transfer or gift. There is an important distinction between the presumption of resulting trust, I repeat, the presumption of resulting trust, and the resulting trust itself. The presumption is an inference to be drawn from the existence of other facts, whereas the resulting trust is the equitable response to these facts, proved or presumed. The law of equity, equitable response, which I mentioned earlier, the law of equity is a branch of law that focuses on fairness and justice. It provides remedies that are not available under common law. The presumption of resulting trust is based on the traditional common sense presumption that outside of certain relationships, certain close family relationships, an owner of property never intends to make a gift, okay? And by extension, a person who provides money required to buy a property intends to obtain an equivalent equitable interest in the property acquired. Equity, the branch of law that I just mentioned, with its realistic grasp of human motivations, assumes bargains and not gifts. The Court of Appeal noted that in the normal course of events, people who spend large sums of money to buy property do not usually have altruistic or generous intentions. And regardless of who is registered as the owner on paper, the person who actually paid the money expects to derive a return from their investment in the form of a proportionate share of the property for whatever they paid. The purchase money resulting trust ensures a default position which gives effect to this expectation. As an aside, let me give you a piece of advice in life. Expectation is the sole cause of disappointment. Disappointment is not caused by any other thing other than expectation. So in life, never expect anything. So back to what I was saying. The presumption of resulting trust is about the intentions of property owners and can be rebuttable by evidence of a contrary intention. So the key takeaway for today: in situations where one person pays for property but registers it in another person's name, a resulting trust is presumed unless there is clear evidence of a gift. You should look at the evidence of intention. To rebut this presumption, clear and convincing evidence of the payer's intention to make a gift of the property is required. This also has an impact on estate planning because this case highlights the importance of clearly documenting intentions when transferring property to avoid future disputes. The case also underscores the need for clear documentation and legal advice in estate planning and property transactions. It serves as a cautionary tale for individuals to explicitly state their intentions when registering property in someone else's name, whether as a gift or as a trust. So thanks for watching this video on purchase money resulting trust.